The question number 4 relating to the contract of Bailment is state briefly the law of lien and describe the different types of lien. So exactly the very meaning of lien as provided under section 170. So lien is a right in one person to retain or to refuse or to deliver property which is in his possession and which belongs to another until the other has discharged legal obligation to the farmer, and as per the provisions of section 170 of the Contract Act, where the bailee has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labor and skill in respect of the goods bailed, he has, in the absence of a contract to the contrary, a right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. And in relation to section 170, we'll discuss certain illustrations. So the first illustration is that A delivers a rough diamond to be a jeweler to be cut and polished, which is accordingly done. B is entitled to retain the stone till he is paid for the services he has rendered. And illustration 2, it provides A gives cloth to be a tailor to make into a coat. B promises A to deliver the coat as soon as it is finished and to give A 3 months credit for the price. B is not entitled to retain the coat until he is paid. And now we'll go to the very principle of Bailey's lien as under section 170 of the Contract Act. This section expresses the common law principle that if a man has an article delivered to him on the improvement of which he has to bestow trouble and expenses, he has a right to retain it until his demand is paid. So, where a bailee has expended his labor and skill in the improvement of a chattel delivered to him, he has a lien for his charge in that respect. Thus, the artificer to whom the goods are delivered for the purpose of being worked of into form, or the farrier by the for the purpose of being worked out into a form, whose skill the animal is cured of a disease, or the horse breaker by whose skill he is rendered manageable, have liens on the chattels in respect of their charges. So now we'll in that connection discuss the leading case, and that is regarding particular lien, and the very important leading case Chase versus Westmore in 1816. So the very section 170 of the Contract Act deals with a lien of a belly in respect of the goods billed only. The lien can be exercised provided the service involving labor and skill has been rendered in respect thereof, and such service has been rendered in accordance with the contract. For example, in accordance with the purpose of bailment, if service is not rendered in accordance with the terms of the contract, the bailee cannot exercise his right of particular lien. The right of lien being possessory in nature, it cannot be exercised so long as the bailee is in possession thereof. Once a bailee has parted with possession of the goods billed, he loses his right of lien. And regarding that, we'll discuss the very judgment in relation to the leading case Chase versus Westmore in 1816. It was held that where a person does work on goods delivered to him under one entire contract, the fact that the deliveries are at different times does not affect his right to a lien on all goods dealt with under that contract. So, accordingly, where jute was delivered to a pressing company from time to time to be built, but all under one contract. The lien was held to attach to all such contract. And now we'll discuss regarding no transfer of lien, and as it is provided, a bailee of reward cannot transfer his lien to a subcontract without the bailee's authority, as it was decided in the leading case Pennington versus Reliance Motor Works in 1923 by the King's Bench. So now we'll discuss the very position of lien in India. So, in India, various statutes are provided for particular lien as follows. So, the very first one, as it is provided lien for a of a finder of goods as under section 168, and Bailey's lien as provided under section 170. Then number 3, general lien of bankers, high court attorneys, and the policy brokers under section 171 of the Contract Act. Then fourth one is pledges or bonus lien as provided under section 173. And the fifth one, agent's lien as provided under section 221 of the Contract Act. Then the sixth one, unpaid vendor's lien as provided under section 43 of Sale of Goods Act 1930. And so also The seventh one, a partner's lien on surplus of assets of a firm if partnership is resigned on the ground of fraud as provided under Section 52 of Partnership Act 1932. So these are the very rights of a belly as we found under lien. So now we'll discuss the very difference between general lien and particular lien as provided under section 171, and regarding that also we'll discuss a leading case, Brandau versus Barnett in 1864. So regarding that we'll discuss the very difference between general lien and particular lien. General lien of bankers, factors, wire fingers, attorneys, and policy brokers, and exactly in the absence of contract to the contrary to retain as a security for a general balance of account any goods billed to him, but no other person have a right to retain as security for such balance goods billed to them unless there is an express contract to the effect as provided under section 171 of the Indian Contract Act. And in relation to that we'll discuss a general lien is a right to retain any property of another for a general balance of accounts due to the person specified. A particular lien is a right to retain it only for a charge on account of labor or skill employed or expenses bestowed upon the identical property retained. Since a general lien can be exercised in respect of a property of another, it cannot be exercised in respect of one's own property. The general lien, as it is called by way of distinction from particular lien, of an artificer for work done by him on the particular goods in question, was originally established in England as regards bankers and others as a proved usages of trade, but once being so established, it becomes part of the law of merchant and as must to be judicially noticed as any other part of the law as it was decided in the leading case, Brandau versus Barnett in 1864. So, this would be the appropriate answer regarding this question number 4, that state briefly the law of lien and describe the different types of lien. And in our upcoming video, we will discuss the question number 5, what are the rights of finder of goods belonging to another as provided under section 168 and section 169 of Indian Contract Act 1872.